Welcome to Canadian Justice. I'm Chirstine Van Gyn, and today we're discussing a case that was just decided by the Supreme Court of Canada that dealt with something called public interest standing. Public interest standing allows litigants without a direct interest to bring a case representing public interest issues. This means that an organization that may not be directly impacted by a law can bring a claim on behalf of other unnamed individuals who have been impacted. The charity that I work for, the Canadian Constitution Foundation, has acted as a public interest litigant. We've successfully sued the government as an organization over laws that have broad societal harm. If we couldn't bring claims like this, we would need to wait until individuals are actually hurt by an unjust law. In the recent Supreme Court case, which was called the Attorney General of British Columbia and the Council of Canadians with Disabilities, the court was asked to consider what the test is for public interest standing. The CCF intervened in this case, as did about 20 other organizations. Here today to discuss the case and what the Supreme Court held is the lawyer who represented the CCF in the case, Mark Sheely. Mark, thank you so much for joining today. Now, I started out with a description of what public interest standing is. What can you add to that description? What exactly is a public interest litigant, and what is the role they play in our justice system?
Thanks, Christine. I think it's helpful to start by grounding ourselves in how our justice system ordinarily works. We in Canada have an adversarial civil justice system that typically pits parties, individuals, or companies, whatever the case may be, against others that have a direct conflict over an issue that impacts them both. Similarly, when we have a lot of cases involving constitutional issues, it's often brought by an individual or an entity that's impacted by the government action. Public interest litigants, by contrast, don't have that direct, specific impact. It's not impacting them directly. They don't have a cause directly against the government. Instead, they have a genuine interest in the matter at play because of their constituency or the matters in which they're engaged as public interest groups or advocates.
So what this case was really about, I mean, we'll get into the meat of what the actual merits of the case are, but what went to the Supreme Court was really the clarification of the test for public interest standing. So can you tell us, what did the Supreme Court hold? What is the test for public interest standing?
Yeah, so the Supreme Court affirmed a test that we had all understood that's been in existence for about 10 years. And it's really, there's three elements that the court needs to ask itself. Does the case raise a serious justiciable issue? Is this a matter that's worthy of the court's time? Is it something that's worth considering? Second point is, does the litigant actually have a genuine interest? So although they're not directly affected, are they somebody or some organization that should be engaging in this matter? The final point is an evaluation of whether the proposed proceeding, is a reasonable and effective means for adjudicating the issue. So that's an evaluation of the pleadings and considering overall, is this going to work? What are the alternatives? Should the court permit this case to go ahead, or should it not? Because there are other ways this could be addressed.
So this was what the Supreme Court decided, that you said that they affirmed the test. So is this restatement by the Supreme Court, is that a change to the old test? Is it keeping it the same? Is there anything that's different?
Yeah, I think it's fair to say that the test is not different, in and of itself. But what's really important in this case is that the Supreme Court provided some really clear guidance for parties on how to apply that test and how it's going to work in different contexts. I think what's important to understand is organizations that want to participate in litigation have to dedicate a lot of resources to even get a case off the ground and to get involved. And having this clarity really ensures they can assess, okay, is this the right case for us? What do we need to do to satisfy that standard? And if it's not, we're not going to start investing the time in it now, only to be defeated on a standing motion some years later.
Yeah, it cannot be overstated, the importance of clarity in the law. And you are absolutely correct that for organizations like the Canadian Constitution Foundation, a big challenge is actually finding individuals who are willing to put their names forward to challenge a piece of law. It takes a lot of courage to do that. So I want to talk about this a little bit more, but we've got to take a commercial break. So we will dive further into this when we come back. Welcome back to Canadian Justice, where we're discussing the issue of public interest litigation with lawyer Mark Shealy and a recent decision from the Supreme Court of Canada that clarified the test for public interest standing. So, Mark, you said that this decision from the Supreme Court in Council for Canadians with Disabilities and British Columbia, that decision has added clarity. Is there any other way that this decision might make it easier or harder for organizations to sue the government? Or really, would it kind of just be the same?
I think if you're a real purist, you might say it's the same test fundamentally, but I really do believe it will make it easier for the right organizations with the right cases to proceed. And conversely, it will make it easier for the government to challenge cases that are inappropriate for the courts. So at some level, everybody wins here because it's providing the clarity for courts below and what they should be looking at and what cases are appropriate to be brought forward by a public interest litigant.
So one of the things that was fascinating to me in this decision was that the Supreme Court rejected the government's argument that in order for an organization to get public interest standing, there needs to be a directly affected plaintiff. And the Supreme Court rejected that. What can you add to expand on what the Supreme Court held and the significance of that?
Well, the Supreme Court, I think, fundamentally recognized that requirement is antithetical to the entire notion of public interest standing. And tethering public interest litigants to individuals effectively undermines, and that's huge. It's very difficult for an organization to identify plaintiffs to work with, and in a variety of matters, having counsel represent a group of individuals and an organization may be more challenging than acting for an organization alone, especially on a pro bono basis. So appreciating all of those things, it's incredibly helpful to the public interest community and for those of us in Canada that want to ensure that there are checks and balances on government and that the court system can be adequately accessed to ensure governments aren't abusing their power, that they can bring cases without needing to identify an individual.
I think that the factual background of this case in particular really shows the challenge of finding individual plaintiffs who are directly affected. Because in this case, the background involved mental health legislation, and there originally were individual plaintiffs who were participating in the challenge. But a lot of these individuals, and because of the nature of the law, a lot of the people affected are kind of on the fringes. They are already suffering with mental health challenges. So what can you add to the factual background of the case, the challenge, that led this ultimately to the Supreme Court?
Yeah, so the underlying issue is very it's very sensitive. So there's some legislation in British Columbia that, in effect, permits involuntary patients to be treated, given psychiatric treatments without their consent, even in circumstances where those individuals have the capacity to deny consent to those treatments, or where they have appointed substitute decision makers who disagree with those treatments being provided. Obviously, in the space of mental health, it's a classic example of where individuals aren't going to want to step forward and pursue claims at the outset. It's a fundamentally personal issue for many people, and to expose yourself to the litigation process is a huge challenge. And I want to broaden that out. It's really for any litigant. I mean, volunteering to be somebody who will pursue a case when there's no financial benefit at play, take a huge amount of time, emotional energy. It's tough for anyone.
Yeah, and I can certainly understand how with the nature of this particular legal challenge, made it even harder to work with individual plaintiffs. What was interesting about this case was the court actually rendered a cost award against the government. We've only got about 30 seconds. What can you say about that? Is that unusual?
It is unusual. The cost award provided the CCD with all of their legal costs for the entire motion, appeal, and appeal to the Supreme Court, and it's very rare, and it's a recognition of the efforts that were put in and the level of obfuscation from the Attorney General in bringing these motions.
Well, I mean, to have all of those costs covered, I don't actually know the quantum of the cost, but given how long this litigation took, I imagine it was extensive. Welcome back to Canadian Justice, where we're discussing the role of public interest litigants and a recent decision from the Supreme Court of Canada. Mark, in this decision, well, at the appeal, the government argued to limit public interest standing because of concerns they say should exist over litigating what they call hypotheticals. They said that the government said challenges need to be grounded in real facts. So how did the court respond to that concern?
Well, I think the court responded by recognizing it is a legitimate concern, but there's a difference between a hypothetical and a situation where a party has pleaded facts that have occurred. And the question is more about how they're going to prove those facts. Mm-hmm. And I want to be clear. The government's position, a concern over hypothetical facts is valid, completely legitimate, and truly hypothetical cases that have no grounding in reality shouldn't be the subject matter of our court's time. What the government was saying wasn't really anything to do with hypothetical facts here. This happened to real people. The only question was, how was the CCD, or how will the CCD prove that those facts did in fact occur? Mm-hmm. That's what's really at stake here.
So one of the things that stands out to me in this case is that this is about organizations' ability to sue the government. And I don't want to be cynical, but certainly it seems like it would be in the government's interest to argue for a really restrictive test that makes it harder for them to be sued, especially if they're being sued by a vulnerable group who is not well positioned to represent themselves as individual plaintiffs. The best positioned people to sue on their behalf might be an organization. If the government makes it really hard for an organization to sue the government, I mean, they're not going to have to pay any damages. They're not going to have to change any of their laws. Am I being a cynic, or is that really what's going on here?
I don't think you're being too cynical at all. There's an element, and in particular in this case, of the government wanting to use standing as a way to avoid meritorious challenges that will be difficult for them to win. They will no doubt have an incentive to avoid cases that they are concerned about losing, or to try to set the circumstances best for winning, or in an ideal world from their perspective to not even have to litigate the case. I mean, the irony here is the government, on the one hand, was challenging the standing of the CCD to bring this case. And at the same time, there's a class action proceeding that relates to similar issues in BC, or the government is fighting the certification of that class action. And they want to have it both ways. They really don't want any cases to proceed against them, it would appear.
I certainly see it as sort of self-serving of the government to argue this way. Now, there have been a lot of cases that have been brought by public interest litigants over the years. Obviously, my organization, the Canadian Constitution Foundation, has successfully litigated some cases. For example, we litigated a challenge to Canada Election Act on a censorship issue successfully as a public interest litigant. What are some other examples of some, really famous cases brought by public interest litigants so that we can see the importance of this type of litigation in Canada's justice system?
The case I'd like to mention, perhaps one of the most famous, is the case called Vriend against Alberta. And Mr. Vriend was a gay individual who had suffered workplace discrimination and brought a challenge to Alberta's human rights legislation, which did not provide protections for based on sexual orientation, being gay or lesbian, etc. Mr. Breen had a legitimate claim on those provisions in the Act that concern employment matters, but he wanted to challenge the whole Act and establish a principle for gay individuals in Alberta generally. And the government fought him on that and challenged his standing. The Supreme Court granted it, and he ultimately succeeded in establishing that constitutional right for sexual orientation as an unenumerated ground.
And did you say in that case the government had also challenged his standing?
Yeah, they challenged his standing to challenge any of the other provisions in the Act that didn't specifically relate to employment law matters.
Yeah, I mean, I mentioned earlier that I feel a bit cynical saying the government is using these procedural motions to try and block meritorious claims, but it certainly doesn't seem to be a new phenomenon, at least. We've got to go to commercial break now, but when we come back, I want to talk a little bit more about the decision itself and what CCF, my organization, argued in this case, with you representing us at the court. Welcome back to Canadian Justice, where we're discussing the role of public interest litigants in the Canadian judicial system. Mark, you represented my organization, the Canadian Constitution Foundation, at the Supreme Court. Can you explain what the CCF argued the test for public interest standing should look like, and how did the court respond to those arguments in their decision?
Yeah, so the CCF really had a couple of concerns identified. Fundamentally, they wanted to maintain a broad approach and flexible approach to public interest standing. And the major points that we made were that the government's argument, although they didn't state it in quite these terms, but in effect, their requirement that a private litigant should be included in all cases, that we wanted a clear repudiation of that, and the Supreme Court did so. We also wanted to emphasize to the court the importance in recognizing that what is in the public interest is an evolving thing, and that demands a flexible approach. And the example that we used was, the concern arose because the Chamber's judge had sort of ruled against the CCD at first instance, in part because they were an organization committed to disabilities, and the case involved mental health issues, which was not exactly the same thing. We really wanted the Supreme Court to reject that line of thinking, because organizations that are responsible and have a demonstrated history of responsible advocacy, like the CCF, shouldn't be precluded from pursuing cases because the issues of the day, based on what governments are doing, have evolved and changed.
Yeah, certainly. There were a lot of interveners in this case. I think there were over 20. Some of them were other levels of government, and some of them were organizations. So were the other governments arguing for a more restrictive test? Do they have the same interest here that the BC government had to narrow the scope of that test to protect themselves from being sued by organizations?
Yeah, it's interesting. Your cynicism is, again, maybe fair. This case was unique in that all the attorneys general were united in seeking a more restrictive approach for a variety of reasons. And all of the interveners, and this is not typical, but all of the interveners were united in advocating for a broad, flexible standard. And these interveners, included not only the CCF, the Canadian Civil Liberties Association, Eco Justice, I believe, was one of them, the National Council of Canadian Muslims, the David Asper Center for Constitutional Rights, West Coast Legal Education and Action Fund, a wide variety of organizations and interests here, all united in advocating for a broad, flexible approach.
And certainly, I guess the day went to those public interest organizations ultimately with having the test clarified and maintained to be broad and flexible. One of the other arguments, we've got a minute left, in favor of a public interest standing is that it allows organizations to challenge a law before harm actually be done. So can you give me an example of that and maybe expand on why that's so important, especially in a case like this one where the underlying facts relate to something as controversial as non-consensual medical treatment?
Well, I think it's important to look at legislation that is obviously infringing on rights. The CCF brought a case recently challenging the constitutionality of some restrictions on expression in the Canada Elections Act, which were so obviously infringing. The only issue was whether the infringement was justified. And in cases like that, and even more so where the harms at issue are even more dramatic, I think Justice Jamal used an example of what if the provision in question, this was an oral argument, he asked the question to the Attorney General, what if it had permitted the government to conduct a lobotomy on somebody without their consent? Would that require an individual affected plaintiff first? And the answer has to be no, it has to be.
That's all the time we have today. Mark, thank you so much for joining us today and for your work on this case.
Thank you.
We've heard today about a recent case that was decided by the Supreme Court, a case that my organization, the Canadian Constitution Foundation, intervened in. This case is core to the work we do at the CCF. We have litigated a number of cases as public interest litigants and successfully had unjust laws struck down in this capacity. I'm happy with the result in this case, but what do you think? How easy or hard should it be for an organization to sue the government? You be the judge. Thanks for watching, and remember, a freer Canada starts with you.